the core of most abusive relationships are two central themes that we tend to see: power and control. Using intimidation, and this can be making someone afraid by using looks, actions, gestures, smashing things, destroying property, displaying weapons, sometimes even abusing pets. We refer to this as either a hybrid or a quasi-criminal situation, because although a restraining order is civil in nature, violations of that restraining order are criminal in nature.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Alyssa Haskup and Angelica Mercado. Alyssa D. Haskup is a partner in her firm's criminal practice group. She represents adult and juvenile clients who have been charged with criminal offenses throughout New Jersey, zealously advocating to protect their rights. Alyssa's trial experience led to her recognition by the New Jersey Supreme Court as a certified criminal trial attorney in 2024. Certified attorneys account for less than 2% of the attorneys in the state. To obtain the certification, Alyssa had to demonstrate a high level of experience, education, knowledge, and skill in criminal law and procedure, and had to be recognized by the members of the judiciary and her peers as having sufficient skills and good reputation in the field of criminal law. Angelica N. Mercado is a New Jersey family law attorney with the law firm of Einhorn, Barreto, Frost, Botnick, Nunn, Musnano, PC, dedicating her practice to aspects of divorce, custody, support, and domestic violence matters. Angelica presently serves as a trustee of the Hispanic Bar Association of New Jersey and the board of the Association of Latino Professionals in America, New Jersey. Angelica frequently presents on subject matters pertaining to domestic violence and family law litigation, including CLEs with various organizations and platforms. The webinar presentation that you're about to watch will be approximately 1 hour, and Alyssa and Angelica will be taking questions from the audience at the end, time permitting. So if you have any questions that come up that you'd like them to address at the end of the presentation, please be sure to submit those by clicking on the Q&A button in the control panel at the bottom of your screen and submitting them there. Now, without further ado, here are Alyssa and Angelica to discuss shifting laws shaping justice, policy, and legislative trends in domestic violence law.
Hi, everyone, and thank you for joining us. Just a quick course overview. We will be discussing today, obviously, the basic definition of domestic violence, how you may see domestic violence in your general practice, and obviously we understand that individuals are joining us from throughout the country. So when we talk about policy and legislative trends, we're going to try to do that on a much broader scale. Obviously, Angelica and I both practiced in New Jersey, so our experience is limited to that. But in preparing for today's seminar, we wanted to make sure that we gave everyone a much more broad overview.
At the outset, domestic violence is a term that we hear in our practices often, that we hear in everyday life, on probably an almost daily basis. But what domestic violence is pretty ambiguous in terms of the colloquial discourse in our day-to-day lives. Domestic violence under the law is generally characterized by a domestic relationship, whether that be roommates, spouses, romantic partners, household members, etc. And it's defined by a pattern of abuse in that relationship to gain power and control over the other. Again, abuse is another term that's used colloquially and is ambiguous in terms of how that's used in people's day-to-day lives. And that it's because it's a broad spectrum of behaviors that fall into that category. It's physical, sexual, emotional, economic, psychological. It can be done on direct, indirect interactions, can be done over with the use of technology and social media. And the courts are cognizant of this ever-evolving definition and the forms in which domestic violence comes before the courts. So these behaviors are intended to intimidate, manipulate, humiliate, annoy, cause fear, cause harm, and negatively impact people's lives, and the intended victim of those behaviors. So when we look at domestic violence in the scope of our practices, we have to have this really broad vision of what it can look like. An example I think of today and in the last few years is how immigration status is something that's used to cause fear, to intimidate, to manipulate. And these are the kinds of behaviors that it might it might not necessarily be written textually into a statute, but we look at the intent, we look at the recipient and the relationship, and we look at the outcome. We look at what fear that instills in the intended victim. And again, as practitioners, our job is to communicate what domestic violence is under the law and what that looks like in real life.
So the way that I often describe it, and I use this language, that at the core of most abusive relationships are two central themes that we tend to see: power and control. And the most commonly used tool that courts and attorneys use to assist in explaining these themes to victims of domestic violence is something called the power and control wheel. And we'll talk about this and this concept throughout this presentation. I can say that in the state of New Jersey, we use a modified version of this wheel, but the power and control wheel, and I'll put that up on the screen for you right now. So the power and control wheel, and we call it the Duluth model because it was created by the Domestic Abuse Intervention Project in Duluth, Minnesota. And I provided the link to their project and some more information in the slides. But this has been around since the 1980s. And in the 1980s, DAIP interviewed domestic violence survivors about their experiences. And during these interviews, they documented what the survivors had indicated were the most commonly used behaviors or tactics by their abusers that were occurring in these domestic violence situations. So the 8 behaviors or tactics that were chosen for the power and control wheel were the most universally experienced. And so obviously right at the center of the wheel, you'll see power and control. And then around the wheel, you'll see what they described as the 8 most commonly used behaviors or tactics that occurred in these domestic violence situations. So as you can see, using intimidation, and this can be making someone afraid by using looks, actions, gestures, smashing things, destroying property, displaying weapons, sometimes even abusing pets can be considered intimidation. And obviously, as things have expanded over the last number of years that this has been around, these definitions have also expanded. But it also includes using emotional abuse, putting individuals down, making them feel bad about themselves, calling them names, making them think they're crazy, playing mind games, humiliating them, making them feel guilty, and also using isolation. And this is where you'll really see the control. The isolation can include controlling who an individual sees, what they do, what they read, where they go. Um, Jealousy we'll see a lot in these isolation tactics. Minimizing, denying, and blaming, making light of abuse, not taking concerns seriously, saying that the abuse doesn't happen. I think in this day and age, a lot of people tend to throw around the term narcissist or narcissism, but we start to see that in this domestic violence context, the minimizing, the denying, and the blaming. And also using children, making an individual feel guilty about their children, using the children to relay messages, whether they're positive or negative, using visitation to harass individuals. And Angelica is going to touch on this a lot more, obviously, in the family context. But unfortunately, sometimes during custody exchanges, children are unfortunately used a lot in this domestic violence context. Now, this is an older model, but obviously using male privilege was certainly something back in the 1980s that was very prevalent. But treating women like servants, making all the big decisions, we start to see this. And again, this ties in with the next one, using economic abuse. But a lot of them go hand in hand. So being the one to define the man's role and the women's role, being one to refer to the house as the master of the castle, things of that nature. Using economic abuse. And we're seeing this more and more, I think, at least in my practice. Controlling finances, whether it's giving the wife a very minimal budget. You have $200 to spend on groceries for the week. Preventing her from getting or keeping a job so that you can make sure you understand where she is at all times, that she's home. Making her ask for money, giving an allowance, things of that nature. And obviously using coercion and threats. And those can be threats to cause harm, threats to hurt her, threatening to leave her. I know we touched briefly on immigration, threatening to report her to ICE, and sometimes making her do illegal things. So you'll see a lot of this. And again, this wheel actually dates back to the 1980s. So you can see obviously how it's evolved over time. But you'll see a lot of these themes as we start to talk about things a little bit more today. So now we're going to touch briefly on domestic violence and how we see it in our various areas, the practice of law. And obviously, as Nina indicated, my primary area of practice is criminal law. I'm a former prosecutor, and I've been on the defense side for well over a decade. But in my line of work, we generally see domestic violence. I get calls, individuals tell me, I've been charged with domestic violence. That's not really necessarily accurate. And I also use this phrase a lot, that domestic violence is a term of art, right? And it's used to describe a category of offenses wherein the parties have some sort of domestic relationship. And Angelica touched on this briefly. That can be anything from family members to roommates to a child in common to a prior dating relationship. There's lots of things that would fall under domestic violence. But domestic violence, when we're talking about it in the criminal realm, can include acts of physical violence, most seriously murder, attempted murder, various assaults. Some states refer to it as battery. Here in New Jersey, we have assault. There's simple assault and aggravated assault, as well as sexual violence. It can also be threats of action. And here in New Jersey, we have a crime that's referred to as terroristic threats. I hate the word terroristic because people tend to think terrorism, but it's actually a threat that is designed to terrorize. There can also be weapons offenses. We call them technological actions. That can be harassment that's done through social media, through the use of a phone, also invasion of privacy. And in some states, you will also see domestic violence that goes so far as to include emotional abuse, psychological abuse, or other coercive behavior. So Angelica, if you want to jump in on the family law, I know that's your area of expertise.
So in the context of family law, first I'll start out by saying that restraining orders, protective orders, can be civil or criminal in nature. So when we talk in the family law context, we're most often talking about civil restraining orders or civil protective orders. There's the temporary order and the final order. And when we look at the underlying acts that constitute the acts of domestic violence, they have relevance in terms of matrimonial disputes and the dissolution of the marriage itself and the custody. So beginning with what I have on the slide as a Tevis claim, Tevis refers to a case in New Jersey called Tevis v. Tevis. But what it is a marital tort. The marital tort, as we probably all know, is a tort that occurs within the context of the marriage. Personal injury, it refers to abuses, assaults, batteries, intentional infliction of emotional distress. And the result of that isn't the divorce in of itself, but it's a claim asserting a cause of action for damages arising out of that marital tort. In most states, now in 2025, spouses can assert a claim for a marital tort either within their divorce action or separate and apart from that divorce action. There are states that still preserve a total or partial interspousal immunity, which creates a procedural and legal obstacle to filing and arguing and proving your marital tort claim, because obviously with interspousal immunity, there are protections to communications and events that occur within that marriage. However, there are also many states like New Jersey, New York, I believe California is one of them. Long list of states that have abolished in whole or in part this concept of interspousal immunity. And the result of that is the ability to assert a claim for damages, money arising out of a harm and injury that occurs between partners. A few procedural things to know about these types of claims. In New Jersey, that personal injury claim, that marital tort claim, must be asserted within the context of the divorce action. But in most states, that isn't the case. In most states, a partner can file a separate action for damages arising out of a marital tort in their court's civil part. However, the thing to be mindful of is statute of limitations to those acts that constitute the underlying harmful act, the underlying tort. The other element of that is that if tried separately, the spouse who's asserting the claim for a marital tort has the right to a jury trial. In New Jersey, while a marital tort must be filed under the entire controversy doctrine with the divorce action, in order for that spouse to have a right to a jury trial as to their claim for damages, the claim has to be bifurcated. And but that doesn't apply to most states. Most states, it can be its own separate civil action. And what does that mean in practice? When two parties are married, we're often dealing with the same pot of money in which damages can be distributed from. So this impacts equitable distribution. This also impacts the timeline of when the harm occurred and how that injured spouse, that injured partner, is going to be financially impacted by the distribution of damages. So just a few things to be mindful of. What every state has, in one form or another, is a factor in their custody statutes that addresses domestic violence or a history of violence within the family as an element of a child custody analysis. All states use the best interest of the child and set standard in terms of making determinations as to custody, and that standard is supported by enumerated custody factors. And every state either has an outright factor that says domestic violence. In New Jersey, it's called the domestic violence history factor. In California, it's called the history of family violence or substance abuse is packaged into that factor. But there's also, every statute will also have a catch-all that seeks to capture any factor, any fact that would bear on the welfare, safety, well-being, and best interest of that child. So in making an argument custody case, the history of domestic violence is a critically important component of the case, and family law practitioners can be very strategic in how to package that history of violence and the history of family violence, and how the children were involved in that history and violence in terms of how they prepare their case. The other family law issue that often arises is the access to property, and from that physical access to the children. So access to property, we're referring to a marital residence or a shared residence if there isn't a marital relationship. When a party files for a restraining order, more often than not, that party who files for a protective order seeks to retain access to the residence if there's a shared residence. And what that means is that either on a temporary basis or on a permanent basis, the defendant in that domestic violence action now is is then out of the marital property. This affects equitable distribution. If a marital relationship, this just affects long-term, perhaps partition claims. And then in terms of custody, this affects the elements of stability and housing for how that defendant party on the defending end of a restraining order can now assert their claim for custody and parenting time pending the resolution of a domestic violence action. So this in the family law context, and those claims are adjudicated by family law judges. However, there can be a separate protective order entered by the state against the defending party. That is a criminal cause of action against the defendant, and what that means is that there is a conviction or a non-guilty on the opposite end of that case. So when we deal with civil protective orders, we call it quasi-criminal in practice because while there can be criminal and civil liberty implications to those civil restraining orders, ultimately, if somebody's found guilty, if somebody's found to have committed a predicate act of domestic violence in a civil context, the consequence isn't a loss of liberty, and it isn't a criminal conviction, although there are criminal implications to that, and we'll discuss that later in the presentation. However, when the state or the municipality files for a restraining order and for argument's sake, they prove their case and there's a guilty conviction at the end of it, that is a criminal conviction, whether it's at the superior court or the municipal court level. And what that case, tried by a state or municipal prosecutor, brought by law enforcement, does not require a victim's participation or consent to pursue, although prosecutors often do prefer to have a cooperating victim, and Elisa can, from personal experience, can attest to that. But it's a cause of action by the state against the defendant versus a civil protective order, which is a cause of action by a victim against that defendant. And the outcomes of those two types of causes of action are different, although both have their criminal elements. One is purely criminal and one is quasi.
Agreed. And I'll just jump in for a quick second. So in the criminal context, there can also be restrictions that are placed by the state or by the judge out of concern based on the nature of the allegations that can also have family law repercussions. For example, if someone is charged with a serious crime of domestic violence in the state of New Jersey, ultimately they're going to come before a judge, whether it's for a detention hearing or for their initial processing appearance to be released, and the judge has the opportunity to place certain conditions. Those conditions can include don't return to the scene of domestic violence, which may be the marital residence. Those conditions can include don't have any contact with your minor children unless DCPP, which is New Jersey's version of DIFUS or Child Protective Services, unless they say that their case is closed without any negative finding. So there are certainly things that can be done in the criminal context that will have repercussions in family court and vice versa. So you'll see that exclusively in the criminal actions. And then we also have this kind of hybrid area that we operate in sometimes where we talk about these protective orders. And here in the state of New Jersey, we call them restraining orders. And obviously there's temporary and finals. But those are orders that are offered to victims of domestic violence. Generally speaking, there must be some sort of domestic relationship for you to qualify for those protections. And there also must be what we call a predicate act of domestic violence that prompts the filing. And so oftentimes, like Angelica said, we refer to this as either a hybrid or a quasi-criminal situation, because although a restraining order is civil in nature, violations of that restraining order are criminal in nature. So in New Jersey, like I said, there's certainly circumstances under which you're going to have implications in many different areas. And so it's important to understand how domestic violence may rear its head in your area of practice in your state. So at this point, we're going to move on to some of the legislative and policy trends that we've seen. And I think one of the areas that we've seen the most in the last few years is this area or this concept of what we call coercive control. And so when we talked briefly about the power and control wheel, and as I indicated at that point, many versions of this wheel are used throughout the United States to aid victims of domestic violence in some context. But that power and control wheel is full of references to coercion, as well as to intimidation, isolation, and control. However, and very interestingly, many states did not actually consider coercive control to be domestic violence until recently. And I can tell you that in New Jersey, it wasn't until the beginning of 2024 before coercive control was actually made a part of our laws. And in my mind, unfortunately, in the state of New Jersey, coercive control is still not considered to be a criminal act of domestic violence. We'll talk a little bit more later about how we see coercive control, at least now in the state of New Jersey. But many states are starting to evolve. And I think that this is one of the concepts that we've seen change the most over the last few years. And that's why I indicated, thankfully, it's beginning to change, because the irony of the situation is that the power and control wheel, which again is replete with these references to coercion, goes back to the 1980s. But it hasn't been until recently that different states have started to pass coercive control laws. Now, some states had passed exclusive coercive control laws. Other states, including the District of Columbia, have laws which cover the concept of coercively controlling behavior, and those usually relate to protective orders and or some sort of family law issue, which, as Angelica mentioned, sometimes it may arise in the context of this best interest of the child issue. And so that's generally how we're seeing it now. So what we're going to do now is we're going to take you through, and this is certainly not an exhaustive list, but we tried to pull from, let me just jump to the next slide. And I put these in date order. So in terms of when they were enacted. And what we tried to do was take a sampling throughout the country of some of these laws. And as you'll see, there are some states that have gone so far as to criminalize coercive control. And then other states have fallen into line with the concept of, well, we're just going to revise our laws to include this coercively controlling behavior. And so, Angelica, why don't you jump in with the first slide, and we'll start to talk about, I think the first big law change that we saw was probably almost 10 years ago now, in 2016.
Correct. And that was in Michigan. And interestingly enough, the Michigan law has less to do with the actual prosecution or the pursuit of a protective order, but mediation in domestic relations matters. So for us family law practitioners, for example, there are almost always some type of mandatory mediation programs in the context of resolving a divorce or resolving a family matter outside of a marriage. So we call them non-dissolution in New Jersey. But when there is a protective order or some type of history of domestic violence in these relationships, mediation becomes a little problematic insofar as you're either actually or in effect putting two people with a history of violence between them in a room or in a Zoom room or in a situation where they have to interact directly, and the dynamic of power and control is so unequal that mediation loses its intended effect. So in 2016, Michigan required mediators in these matters to make a reasonable inquiry as to whether either party has a history of a coercive or violent relationship with the other. And that's built into the law. In New Jersey, for example, it's not built into the statute, but our court mediation programs actually have a separate and voluntary mediation program for parties with a history of domestic violence. And these mediators are specially qualified, and they have to get their special certifications in order to qualify to mediate these types of cases. So in 2019, Washington moved the needle a little bit. It actually actually amended its definition of dating violence in the context of protective orders. So dating violence now is defined as abusive or coercive behavior where a dating partner uses threats of or actually uses physical, emotional, economic, technological, or sexual abuse to exert power or control over a current or former dating partner. And again, this looks to the intent to exert power or control, to coerce action, to coerce a behavior from the victimized party. So whereas coercive control under the Washington statute isn't in and of itself an act constituting an act of dating violence, now Washington in 2019 began to look at the actual nature of an act, its intended effect, and the factual dynamics of the power relationship between the two parties. Um, since 2019, Nevada has enumerated acts that constitute domestic violence to include coercion. And this is a step forward from what Washington did, because now coercion in and of itself is an act constituting an act of domestic violence. It criminalizes coercion where there's an intent to compel another to do or abstain from doing an act which the other person has a right to do or abstain from doing. So now, when you look at a protective order, we don't have to, in Nevada, you don't have to look to couch this coercive act as something else, as harassment, as threatening behavior. But the coercion in of itself is the domestic violence.
And I think before we jump into the next slide with New York and California, I think that those are the most, I'll call them progressive states. It's states that have included coercive control as an act of domestic violence and have also gone so far as to criminalize coercive behavior. And so you'll see that a lot of states are almost kind of dancing around this issue. But in my opinion, the most progressive ones are the ones that have gone so far to make it both a criminal act as well as to include it in this, what we'll call the definition of domestic violence. So in New York, and New York's changes also occurred in the year 2019, New York has kind of gone halfway. It's and actually not as far as other states in terms of the definition of domestic violence, because in New York, coercive control has not yet been expanded to include non-physical tactics. It only includes physical tactics. And so it has a very limited application in the context of domestic violence protective orders, which is usually where we see it. New York, similar to New Jersey, has introduced legislation to criminalize coercive control, but it has yet to become law. So essentially what we're left with in New York is that in 2019, they modified their definition of a, quote, victim of domestic violence to include any person over the age of 16. And I found that to be interesting because in some states, we talk about 18 being the cutoff, and anything below that, there are different mechanisms through which you can seek protection. But they're indicating that any person, oh, excuse me, I'm sorry. Just lost my slides here. Any person over the age of 16, any married person, or any parent that is accompanied by his or her minor child or children in situations in which such person or person's child is a victim of an act which would constitute a violation of the penal law, talk about a mouthful, including but not limited to acts constituting, among other things, coercion. So they've used this word coercion, but again, it's a very limited context in which we can actually see it employed. Now, so we're jumping forward now to 2020. In September of 2020, in California, Senate Bill 1141 was signed into law, and it took effect in January of 2021. And similar to New York, the law did not criminalize coercive control. Rather, it amended the family code in California to expand the definition of disturbing the peace to include coercive control. So again, you see that phrase there. And therein, the law is defined as, quote, a pattern of behavior that unreasonably interferes with a person's free will and personal liberty. So that's what we're left with in California. And you'll see this a lot of times, the coercive control. Again, you're going to see a lot of similar phraseology that's used throughout the states. And you talk about this pattern of behavior, this pattern of coercive behavior. So you'll see various language, but a lot of times courts are actually looking for a pattern. So on the defense side of things, I can certainly see an argument being made that if somebody only comes forward with very minimal examples, perhaps only one example, that's not going to be a pattern, right? A pattern is something that has to exist over time. And so there's some important distinctions when we start to look at the phraseology that's utilized in a number of these laws, and you think about how that may be employed in your practice, regardless of which side you're on. But if you're on the defense side, potentially, how am I going to defeat this argument? And if there's no pattern, well, it essentially ends there. So again, very important to focus on the language that's used in a lot of these laws. Juck, if you want to jump in with Hawaii.
So in Hawaii in 2020, the definition of domestic abuse was amended such that the coercive control between family or household members is included in the context of restraining orders. So this can play out in varying forms, like Elisa mentioned. Like, we can look at historical patterns of the family dynamic. We call that prior history in our restraining order applications in New Jersey. But it can also be interpreted to include acts of coercive control. Again, as a non-Hawaii practitioner, it would be interesting to look at how the courts actually treat this, because we can look to the coercive control wheel, but unless the statute defines coercive acts, now it's a matter of argument and how we as practitioners package this coercive control between family or household members to deliver our message that this is in fact domestic abuse, domestic violence that requires such relief. In 2020, Mississippi passed a law that expanded the definition of domestic violence to include any pattern of behavior or control resulting in physical, emotional, or psychological harm to a victim committed by a spouse or former spouse of the victim, a person with whom the victim lives or lived as a spouse, etc. And the rest of the definition just applies to who qualifies as the victim under that statute. So while Mississippi did not include coercive control or coercion in and of itself, it's alluding to that pattern of behavior control with the purpose of causing various types of harm to people within this domestic relationship. It's not as progressive as we see in Hawaii, as we see even in California, where it's not as progressive as Nevada, but it's moved the needle in Mississippi to at least allow practitioners and victims the flexibility to communicate a coercive acts in this context of domestic abuse.
So in 2021, we started to see, at least numerically, some more changes occur as well. And in 2021, Connecticut passed a domestic violence related law that essentially established a definition of domestic violence, which included coercive control as a form of domestic violence. And Connecticut coined their law as Jennifer's Law. And in Connecticut, coercive control is defined as a pattern of behavior that unreasonably interferes with a person's free will and personal liberty. So we've seen this language before, and it's now been mirrored in Connecticut. And therein, it allows victims that have been subjected to coercive control by a family or household member. So there you've got essentially the qualifications to apply for civil restraining orders. And it also criminalizes violations of protective orders for certain family violence crimes, but again, similar to some other states we've seen, does not go so far as to criminalize coercive control or coercive behavior. So sticking with 2021, this is when we saw a change in Washington state. The previous slide had addressed Washington, D.C. And in Washington state, the laws were expanded, again, pertaining to these civil protection orders to include coercive control. So kind of mirroring what's happening in some other states, but not going so far as to criminalize it. But now in the state of Washington, coercive control is defined as, and again, you'll see this language a lot, a pattern of behavior that is used to cause another to suffer physical, emotional, or psychological harm. So here you see that it's gone a little bit further than just physical, like we had in New York, that limitation. It's also gone so far as to include emotional and psychological harm. And in purpose or effect unreasonably interferes with a person's free will and personal liberty. So that's what we're left with right now in the state of Washington.
And in 2021, Arkansas added coercive control to its Arkansas Abuse Act. And that coercive control is defined as, again, a pattern of behavior that in purpose or effect unreasonably interferes with the free will and personal liberty of the person. 2021, Missouri added coercion to its Domestic Relations Act and defined it as compelling another by force of or threat of force to engage in conduct from which the latter has a right to abstain, or to abstain from conduct in which the person has a right to engage. And that language mirrors very, very similarly Nevada, which was like kind of the first state to really take that leap to include the word coercion as the act itself, versus alluding to the act through patterns of behavior that implicate power and control dynamics for victims and their ability to act or not act within that domestic relationship.
So jumping forward now to 2023, this is when we saw some changes in Colorado and Nebraska. And initially in Colorado, again, we see this amendment within the family context for the family practitioners. Colorado amended its family code to include coercion, and they use the specific word as an act of domestic abuse that can be considered in the context of protective orders. So now in the state of Colorado, coercion includes, quote, compelling a person by force, threat of force, or intimidation to engage in conduct from which the person has the right or privilege to abstain, or to abstain from conduct in which the person has a right or privilege to engage. So again, happy to see that the word coercion has been incorporated, but the definition is somewhat limited. But interestingly, in Colorado, family court mediators, similar to some other states, have enacted similar requirements. The family court mediators must complete training on coercive control, so it can be recognized. And if certain steps need to be taken to protect the litigants, that can be done. And like I said, Nebraska also in 2023 amended its family code. And specifically, that amendment was relative to the definition of emotional abuse. That definition now includes, quote, coercive tactics as a form of emotional abuse. So the Nebraska statute now indicates that domestic intimate partner abuse and a pattern or history of abuse evidenced by one or more of the following acts, and again, they go so far as to include the word coercion against any current or past intimate partner, or abuser using a child to establish or maintain power and control over any current or past intimate partner, and when they contribute to the coercion or intimidation of an intimate partner, acts of abuse or neglect or threats of such acts.
So in 2024, I'll start with Oklahoma and end it strong with New Jersey, because that's our home turf. We could speak a little bit more in as to our experiential feedback on that. Oklahoma amended the definition of domestic violence to include coercive control by a parent involving physical, sexual, psychological, emotional, economic, or financial abuse. Again, similar to Colorado, while the term coercive control is included, it's a very, very limiting relationship that's covered under this act. So in effect, who can actually benefit the victims that can actually benefit from a coercive control statute in obtaining a protective order is very, very limited. Spouses can't, romantic partners can't, co-parents can't, household members that are not parent in a parent-child relationship can't. So it's a very limited definition of coercive control, and in my opinion, doesn't move the needle as much as it needs, as much as it should, in terms of expanding what the legal understanding of coercion in these domestic violence situations are. In last year, in 2024, New Jersey passed a law that expanded the form of conduct to include coercive control that courts may consider when deciding whether to enter a final restraining order. So, some more specific details, again, because of our own practice. When we are pursuing a final restraining order on behalf of a client, a victim of domestic violence, the application for a restraining order asks about a prior history of domestic violence. And that's really where New Jersey's coercive control law now comes into effect. It's not in and of itself a predicate act that on its own, one single act of coercive control is probably insufficient to obtain a restraining order. Because in particular, the court can now consider a pattern of coercive control against a person that in purpose or effect unreasonably interferes with, threatens, or exploits a person's liberty, freedom, bodily integrity, human rights with the court, specifically considering evidence of the need for protection from immediate danger or the prevention of further abuse. So again, this in practice it is brought up more in the context of a history and the patterns of violence, but in and of itself, a single act of controlling behavior, a single threat of I'm going to withhold your money, cannot constitute a coercive control act of domestic violence. It can, however, it can be an act of harassment. An act can be a terroristic threat and still fall under this concept of coercive control. So it's more expansive than other states, could be more expansive still. And similar to New York, New Jersey has introduced legislation to criminalize that coercive control conduct, but it's not law yet.
And I think in all candor for New Jersey practitioners that although this was a welcome change in our law, it was somewhat disappointing because it could have gone much further. And at least in the state of New Jersey, when we talk about restraining orders or protective orders, we boil it down to two things that you would need to establish before the court. The first is that there was a predicate act of domestic violence that occurred that prompted you to file for protections. And as long as you satisfy that prong, the court will then look at a prior history to determine whether, in the context of that predicate act, a final restraining order is necessary to prevent future harm. And so, unfortunately, in the state of New Jersey, this concept of coercive control cannot be raised as a predicate act of domestic violence. It can only be raised in the context of the prior history. When we look at this pattern, and obviously we've read the language in, and you've noticed that there's some similarities throughout the states in terms of the language that's been now codified. So it was somewhat disappointing in that regard because coercive control oftentimes is a predicate act of domestic violence. It is what prompts individuals to go to court and seek protections. And so now that needs to be characterized differently in the initial application, whether it's characterized, as Angelica said, as harassment or potentially cyber harassment if it's occurring through some sort of technological means. But because we have not gone so far in New Jersey as to either criminalize it or to include it as a specified act of domestic violence, we're limited in that context. And so New Jersey is kind of fallen short in my mind of what we could accomplish with the modifications to our laws as it relates to coercive control. But in that same vein, we are also in keeping with what a lot of states, at least in this particular area in the Northeast, have done.
And the effect of this too is also it impacts victims who don't have access to attorneys far more than attorneys who we as practitioners have an obligation to do our due diligence, be up to date on all the laws that impact our practice and that impact our cases. So we as attorneys can go to court, and even though this went into effect in 2024, we can tell a judge who might not be up to speed on current laws and say, hey, well, the statute says X, Y, and Z about coercive control or patterns of behavior that can constitute these controlling power dynamics in a domestic relationship. And that's why this is what, in addition to other things, may entitle my client to protective order. However, when you see a self-represented litigant, a pro se, go to court and their experience is being threatened by financial control. My husband or wife has cut off on my bank account. My husband or wife is threatening to withdraw my pending immigration application because I'm here on a K visa. Or some other act that a non-legal practitioner will have a more challenging time articulating. I think it's, as practitioners, we have an obligation to educate the courts, who, again, all these statutes that we just explained are within the last 10 years, and judges might not be as up to speed as we are. So articulating that not only for our own cases, but in the interest of proliferating the knowledge of these new developments in the DV in domestic violence cases that judges absorb and then can continue to carry out. Because, again, as I said at the beginning of the presentation, we hear domestic violence and domestic abuse in our everyday lives more casually than what the statutes actually provide for. So what domestic violence is and can be construed as is very ambiguous to many, and some our legal minds are not immune from that. So again, staying up to speed on these developments, and many of these laws are continuing to develop, like New Jersey, New York, which are still pushing for the criminalization of coercive control, and making sure that and holding our courts to account as to the adjudication of these types of claims.
And one last thing before we move on, just in that vein, we are advocates, right? That's part of our job. And so when you are, and I represent both, plaintiffs and defendants on the restraining order side. Obviously, on the criminal side, I'm exclusively defense, but I handle in this day and age probably as many domestic violence cases as I do criminal. So it's important to argue your position, right? And if you believe that you have a client that has been victimized by some sort of coercive controlling behavior, find the language in the statute that you can use to explain to the court in your state why your client is a victim, right? I think this concept of domestic violence, it's a very fluid concept. And go back to that power and control wheel, because there's undoubtedly some version of it that's utilized in your state, and you can pull from that. And most courts will recognize that. And so if courts don't recognize this concept of coercive control or this pattern of coercive behavior or controlling behavior, again, whatever language is being utilized in your state, try to equate your client's experiences to the language that is used in your state, because we're always advocating, and that's our job, right? So the last area that we're going to cover is the judicial trends, and essentially how we are seeing domestic violence being applied as it relates specifically to the Constitution. And so, Angelica, I'll have you jump in first with regard to the First Amendment.
So most, if not all, states include harassment or harassing behaviors as as an act of domestic violence in either civil or criminal capacity. Harassment, cyber harassment, sometimes stalking, they fall into the category of verbal acts, not a physical act of violence that that many might assume domestic violence is, but words, communications. So this has First Amendment implications. And in 2023, the Supreme Court in Counterman versus Colorado addressed the issue of whether the First Amendment requires proof that a defendant had a subjective understanding of the threatening nature of his statements to sustain a criminal conviction under a state's anti-stalking statute. And what the Supreme Court decided was that a statement is a true threat, unprotected by the First Amendment, if the defendant had a subjective understanding of the statement's threatening nature based on a showing of no more demanding than recklessness. What does that mean? That the intent to cause a harm doesn't require that same intentional burden as a reckless act does, more careless. So in practice, what does that look like? In New Jersey, the harassment statute speaks to an intent to annoy, harass, or alarm a victim, an intended victim. So if a threat says if a defendant texts their ex-girlfriend, I'm going to go to your house and punch you in the face, with no intentions actually doing it. Actually, now this defendant is in Europe somewhere, with no plans to come back to the United States, no plans to come back to Colorado in the case of Counterman, or come back to New Jersey. What the New Jersey statute looks to is the intention, and the intention to cause, whether it's an emotional harmful reaction to the victim, or to follow through on it. But does that perpetrator have a First Amendment right to just say what they want willy-nilly? And the Supreme Court says no. A true threat is not protected by the First Amendment, and they have to have some subjective understanding. That means the dynamic between the victim and the perpetrator bears on the understanding of the statement's threatening nature and what that intention can be interpreted to be. We look at California, and for example, in California's harassment statute means a knowing and willful course of conduct directed at a specific person that a reasonable person would consider as seriously alarming, seriously annoying, seriously tormenting, or seriously terrorizing to that person who, and it served no legitimate purpose. So again, the content of the threat itself is less relevant than the intention behind the conveyance of that communication. And the Supreme Court does not protect that speech, and thus most harassment statutes that kind of have that same form, an intent to cause some type of harmful reaction to a victim, is not protected by the First Amendment as free speech.
If you want to continue with Crawford, and then I can jump in, Angelica.
Yep. So Crawford is a Sixth Amendment case, and the Sixth Amendment, as my notes, the Sixth Amendment refers to the right to confront your accuser, the right to a speedy trial, right to counsel, et cetera, et cetera. But in terms of the cases that we're going to discuss here, it's the right to confront witnesses in your criminal prosecution. All the Sixth Amendment rights relate to criminal prosecutions. So the Supreme Court in Crawford, which is a 2004 case, something to be mindful of because the following cases occurred subsequent to Crawford, that Lisa will discuss, was whether the state's use of a victim's statement violated the defendant's Sixth Amendment right to confront his accuser. These issues often turn on the facts, obviously. And in Crawford, the defendant was charged with assault and attempted murder after stabbing a man who allegedly tried to rape his wife. The prosecution sought to introduce a recorded statement by his wife describing the stabbing, and the trial court allowed the tape to be played to the jury and convicted Crawford. Now, speaking as I spoke about earlier in terms of domestic violence and family law, many states still preserve the interspousal privilege. So that means that wife cannot testify as to certain categories of events and communications that occur within the context of that marriage. So she was not able to testify, and thus the defense didn't have an opportunity to cross-examine her as to statements that occurred within the context of that marriage and that event. So the state held that the testimonial statement was not admissible because it violated Crawford's Sixth Amendment right to confront his accuser, to confront the person providing that testimonial statement. And there are Sixth Amendment exceptions, but this did not fall under one of them.
So with that, we'll jump into two cases that were decided in 2006, Davis versus Washington and Hammond versus Indiana. And essentially the issue in both of these cases was characterized by the court as, when are statements made to law enforcement personnel, whether it's during a 911 call or at a crime scene, when are those statements testimonial and thus subject to the requirements of the Confrontation Clause? And essentially what the court did is they said, in order to determine whether a statement is testimonial in nature, the court has to look at the primary purpose of the statement. So in other words, statements are non-testimonial when they are made in the course of police interrogation under circumstances objectively indicating that the primary purpose was to enable assistance to meet an ongoing emergency. So jumping down to example number one, which is pulled primarily from the Davis case, a person's statements to a 911 operator during an ongoing emergency to enable assistance are considered non-testimonial, and therefore they would not be subjected to the requirements of the Confrontation Clause. To the contrary, statements are testimonial when the circumstances objectively indicate that, number one, there is no such ongoing emergency. The emergency component of whatever the situation is has resolved. And B, the primary purpose of the interrogation is to establish or prove past events potentially relevant to later criminal prosecution. So we jump down here now to example two. Statements made after an emergency has subsided with the primary purpose of documenting past events for future legal proceedings or to investigate a possible crime involving past conduct, those are considered testimonial in nature. And that's pulled primarily from Hammond. So I know we're kind of running out of time here, so we'll kind of pick this up towards the end. But I can move into Giles versus California. Again, we're still talking about the Sixth Amendment right to confront witnesses. But this is a case from 2008, so 2 years later. And this case involved an individual who was charged with murdering his ex-girlfriend. And at trial, the prosecution introduced statements that the ex-girlfriend had made to police. And in doing so, they argued that the defendant's actions had actually caused her to be unavailable, and thus he had forfeited, under the circumstances, his right to confrontation. So that was the issue, whether a defendant in a criminal prosecution could forfeit their Sixth Amendment right by wrongfully causing the witness's unavailability. Under common law, we called this forfeiture by wrongdoing, and whether this would constitute an exception to the Confrontation Clause. And so ultimately, the court held that a defendant can forfeit his or her right to confrontation, but they have to intend to procure the unavailability of the witness. So that has to be their intent in order to forfeit that right. So Angelica, if you want to jump in, we'll shift a little bit to the Second Amendment.
Well, we're going to end off strong with my favorite constitutional right in the context of the Second Amendment. So I'm going to start off with two cases and kind of explain them hand in hand because they deal with the same underlying federal statutes. And that's U.S. versus Hayes, the 2009 case coming out of West Virginia, and then Castleman, which is a 2014 case, which, if I recall correctly, came out of Tennessee. And both of these cases involve the Federal Gun Control Act, and specifically the Lautenberg Amendment, which states that federal law prohibits individuals convicted of misdemeanor crimes of domestic violence from shipping, transporting, possessing, or receiving firearms or ammunition. As we know, Second Amendment is right to bear arms. So many states and the federal government passed statutes limiting that in the context of people convicted of certain crimes of domestic violence. And in Hayes, the issue was that the underlying statute upon which the Randy Hayes was convicted didn't require that a domestic relationship exist between the defendant and the victim. That requisite relationship we often see in domestic violence criminal statutes of marital relationship, co-parenting relationship, household members, etc., didn't exist when he was convicted of his misdemeanor crime. So he requested that the federal district court dismiss his indictment on charges for violating the Lautenberg Amendment on the basis that his underlying misdemeanor crime of domestic violence, that statute didn't require the existence of a domestic relationship. In Castleman, the underlying statute did not specify a required element of the use of attempted force, which was a component of the federal statute. So both of the Supreme Court's holding in both of these cases essentially say substance over form. The Congress intended to enact the Federal Gun Control Act and the Lautenberg Amendment to limit the right to bear arms for people convicted of acts of domestic violence, misdemeanor, or of course, more serious crimes, such that the underlying statutes don't necessarily need to mirror the federal statutes if the intention is for a domestic violence act and domestic violence conviction to be the limiting act. So these are criminal convictions that are addressed in Hayes and Castleman. And again, substance over form. Voisine, because we're short on time, I am going to only explain the holding, which held that the federal prohibition on firearms possession for individuals convicted of domestic violence applies to those convicted of both intentional and reckless acts because it's a deliberate decision to endanger another, whether or not the specific harm that resulted was the actual intent.
And last but not least, your favorite too.
Last but not least, Bruin and Rahimi. So Bruin actually does not deal with domestic violence, but I included it here for informational purposes because Bruin was important to the court's reasoning in Rahimi, which was kind of surprising when the case came down. So the holding of Bruin was that the courts should look to state gun laws and decide whether the proper cause requirement of gun laws is consistent with the historical tradition of firearm regulation. This case came about from a New York law that required a special need for self-defense for somebody to qualify for a concealed carry permit. And the Supreme Court knocked down that law and said that it infringed upon the right because the historical tradition of firearm regulation and the right to bear arms in our country did not say that it was only limited to self-defense purposes. So Bruin was a stepping stone for the court's decision in Rahimi, which in my view was a little surprising when it came down because we thought it was going to be limited again. And in Rahimi, Zaki Rahimi was issued a civil protective order, distinguishable from the first two cases, Castleman and Hayes, which dealt with criminal convictions. Rahimi involved a civil protective order. And the order barred him from engaging in certain harassing behaviors towards his ex-girlfriend and her child, as well as owning firearms. Rahimi had assaulted his girlfriend in a parking lot following an argument. A bystander had witnessed it. Rahimi fired a gun at the witness. So this he wasn't he wasn't a great plaintiff for this certain issue before the Supreme Court, because his underlying act of domestic violence involved gun violence. Who knows how it would have turned out if it had just been harassment or cyber stalking or something along those lines, but we as practitioners know we work with the facts that we have. And he consistently violated this protective order. Again, not a great representative for people in this behind this lawsuit. So the issue in Rahimi was whether the Federal Gun Control Act empowered the government to prohibit firearm possession by a person with a civil restraining order in the absence of a corresponding criminal conviction. And applying Bruin's historical tradition test, which is why I included the Bruin case, the court held that the firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. And through both English and U.S. laws, our historical tradition, there has been a consistent historical tradition confirming what common sense suggests. When an individual poses a clear threat of violence to another, like firing a gun at a witness after assaulting your girlfriend in a parking lot, you can be disarmed by the government. And that was a case that came down last year. And if it went the other way, laws like New Jersey has firearms restriction with civil protective orders, and that goes to that quasi criminal nature of civil orders. And the government has the right to restrict your constitutional liberties when it deems that the legislative intent and historical intent was to do so.
So I could probably spend another hour on weapons forfeiture and how we see that in the context not only of domestic violence cases, but criminal cases. And obviously that's employed differently throughout the United States. But at least here in New Jersey, there's definitely mechanisms through which individuals can be disarmed if there's a threat of violence. And we see this, again, employed through various means. So like I said, that can probably be another hour-long CLE, but I see we've gone a little bit over. So Nina, I don't know if you want to just provide them with our contact information. If there's any questions, of course, Angelica and I would be happy to answer those electronically.
Wonderful. Yes, thank you both so much for your time and your insights. I will go ahead and pop their emails into the chat for you all. If you have any questions, please feel free to send them over. Additionally, if you have any issues, you can always contact us and we can help facilitate that as well if you would like us to do so. And we want to thank you so much for joining us for another Justia webinar. As I mentioned earlier today, don't forget to take advantage of a powerful and free legal resource to help you stay in the know, available to all Justia Connect members, our Justia Daily Opinion Summaries. With these, you'll get next day email alerts with concise summaries for the latest court opinions in the jurisdictions and practice areas that you care most about. And you can sign up for those by going to newsletters.justia.com. Thank you all so much for joining and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.